My name is Phil, as Nick said. I'm a freelance journalist based here in Providence, my hometown. And I recently sued the United States government, and I won. And because this is a story really centered around information, Nick invited me to come say a few words, and I'm delighted to be here. This is a story that involves one of the most prolific prescription drug dealers in recent U.S. history. It's a story that's a notable example of the Freedom of Information Act, and it's a story that ultimately has some fundamental reminders about what it means to live in this country, what we're all up to as citizens of the United States. But I will also say, as a bit of a disclaimer, this is a story that played out over the course of 5 years. It involved thousands of pages of legal documents, transcripts, trial evidence, and it's a criminal case. It involves a criminal case that went all the way up to the U.S. Supreme Court and back, so you'll have to excuse me, but this is the very extremely exponentially condensed version. In May of 2007, Dr. Paul Volkman was arrested at his luxury apartment on Lakeshore Drive in Chicago, and he was accused by the government of a massive prescription drug dealing scheme. The government said in their indictment, which was released that month, and also in subsequent press releases, that Volkman and his co-conspirators had worked in pain clinics in southern Ohio and distributed more than 1.5 million pain pills over the course of a few years, which ultimately, allegedly, they said at that time, led to the deaths of at least 14 people. He was, in other words, running a pill mill. And he was doing it in an area that a former LA Times reporter, Sam Quinones, has called, quote, America's pill mill capital, and, quote, ground zero in the pill explosion. So here you have a guy who is allegedly one of the most prolific and fatal prescription drug dealers in recent U.S. history. At the time of his indictment, a DEA special agent says, "This serves as a warning to all medical professionals that if you illegally prescribe medicine for personal gain, you will be prosecuted to the fullest extent of the law." And as it happens, this guy, Dr. Paul Volkman, is a former classmate of my dad. They were classmates and acquaintances for 10 years at 2 different schools. There they are on the left in the 1960s at the University of Chicago. That's my dad on the left, Paul Volkman on the right. To me, anyway, they look almost eerily similar in that photo. And then you see them in a photo I took from a wall composite at a hospital at the University of Chicago in the following decade, a few hairstyles later, a few beard styles later. My dad is there on the left, Charles Eil, Paul Volkman on the right. So these guys were acquaintances. They weren't best friends for 10 years. And when I learned that this former classmate of my father, high school valedictorian, guy who had an MD, PhD from the University of Chicago, was under federal indictment, I actually learned about it 2 years later in 2009, I said, whoa. What happened here? At the time, I was 24 years old. I was just beginning a career as a freelance journalist. I was a recent college graduate. I had admittedly recently read Truman Capote's In Cold Blood, which was one of the books that made me want to be a writer. And this story struck me as definitely something worth looking into. And in fact, I was about to start a 2-year graduate nonfiction writing program in New York, which offered me the perfect opportunity to dive in. So what I did in the summer of 2009 was I started digging in to the extent I could online. I read the indictment, I read articles about the arrest, and I ultimately, when I arrived in New York, sent a letter to Paul Volkman, who was at that time awaiting his trial and living in Chicago, asking if I could interview him. And he said yes. So with that phone call that I received about a week after I sent that letter, I kind of went into hyperdrive for 2 years. I became obsessed. I traveled to Chicago to interview Dr. Volkman. I traveled to Ohio almost 10 times to speak with people in the area where Volkman was practicing. I went to the former buildings where he had, according to him, been treating chronic pain patients legitimately, according to the government, dealing prescription drugs. I interviewed doctors who were experts in the field of chronic pain management. I, to the extent I could, became an expert on this case, and fairly early on, I determined that there was enough for a book here. So even though I was a student, a graduate student, I was working on a book. And the centerpiece of that book, sorry, I'm getting a little ahead of my slides here. There's me at the DEA Museum outside of DC in Arlington. So the centerpiece of this book that was taking shape in my mind was going to be the trial. The question that intrigued me was this guy actually a doctor or was he a drug dealer? And that was in fact the crux of this 8-week trial that took place in federal court in Cincinnati in the spring of 2011. And the trial lasted for 8 weeks. It was a pretty big operation. The government called 70 witnesses. They presented more than 300 exhibits, all in the attempt to show that this highly educated guy had in fact crossed over. This was admittedly a subjective line between the legitimate practice of medicine and drug dealing. We now know that according to the Department of Justice, Paul Volkman was the single largest physician dispenser of oxycodone, the opiate painkiller, in the United States from 2003 to 2005. So this is a big piece of the puzzle of who has been dispensing these medications that we've all heard so much about. But as a reporter, I quickly ran into two significant problems in covering the case, the trial that is. The first was really a story for another day, but I was essentially kicked out of the trial in that prior to the trial, I had been interviewing people on both sides, Paul Volkman, the defendant, and various people who were, as I later learned, going to be called as witnesses for the prosecution. And prosecutors didn't really like that. They saw me as a threat to their case, apparently. I can only guess because they never told me. Why they eventually handed me on the third or fourth day of the trial that I was attending with my notepad and my shirt and tie, a subpoena to testify in the trial. Subpoenas are not optional. Subpoena actually means under penalty. And I had to show up at the courthouse to what they said was testify. It turned out they didn't want me to testify. What they wanted me to do was actually just be out of the courtroom. Because when you are subpoenaed as a witness in a trial, you are no longer allowed, due to rules of witness separation, to stay in the courtroom. You have to be elsewhere. So I was effectively kicked out. That was on day 4 of an 8-week trial. I didn't have the resources or the wherewithal to mount a First Amendment case to regain my seat in the trial. So I just paid attention to the extent that I could from home. And I also said, well, it's not the end of the world. I'll be able to get the record when it's all done, the transcript and the evidence. And I thought that because the Sixth Amendment, which I've since become very closely acquainted with, says that, among other things, trials are public in the United States. It's one of our fundamental rights. You get a public trial. And we often, in our kind of swaggering way, make a point of pointing out to other countries that don't do public trials or do something less than public trials. China, Russia, the recent journalist who was imprisoned in Iran for a while didn't really get a public trial. We don't want to live in a country where they don't do public trials for a lot of reasons. So I figured public trial, it'll be easy enough. But when the trial ended and Dr. Volkman was eventually convicted in May of 2011, and here's where the information part comes in. I asked the court for the evidence the jury had seen. The information produced by a trial, as I said, breaks down in kind of 2 ways. There is the transcript, which kind of reads like a screenplay of what everybody said, and there are the exhibits, which is what the jury saw to the pieces of evidence presented by the prosecution and the defense, in this case mostly the prosecution, to show them what this person did to lead them to their verdict. And I wanted to see this stuff for just pure curiosity, but of course for my book. So I asked a bunch of people and everybody said no. The clerk of the court, the U.S. District Court in Cincinnati, said no. The prosecutor via email said no. I sent a letter to the judge who presided over the case. She ultimately said no. The appellate court Volkman was mounting an appeal, and the appeal happened to be in Cincinnati, where the Sixth Circuit is based. The clerk of that court, in whose possession the evidence now stood, said no. Everybody said no. And so I decided, as kind of a last resort, I would turn to this thing called the Freedom of Information Act. How many people here, just show of hands, have heard of the Freedom of Information Act? Is this okay, it's an info crowd, so I don't need to tell you that much, except that, in essence, the Freedom of Information Act, which was passed in 1966, signed by President Lyndon Johnson, is a law that basically said that information, documents produced by our federal agencies, belongs to the public, and that if you ask for it, unless the government has a very good and specific reason which falls under certain exemptions, they have to release it. In fact, Lyndon Johnson said when he signed the law on July 4th, 1966, "A democracy works best when the people have all the information that the security of the nation permits. No one should be able to pull curtains of secrecy around decisions which can be revealed without injury to the public interest." Now I figured, because I was asking for evidence that had been submitted in a public trial, admittedly one that I had been kicked out of, but a public trial nonetheless, there were no seals or anything, this should be easy enough. It was a little frustrating, everybody had said no, still we were going to be in the clear, and it was less than a year after the trial had ended. Ultimately, to jump forward slightly, Volkman would receive 4 consecutive life sentences. He was ultimately convicted of being responsible for causing the deaths via his drug dealing of 4 of his patients. And the judge, who was no great fan of his, gave him symbolically 1 consecutive life sentence for each of those deaths. That is what as far as I can tell, one of the longest criminal sentences for a doctor in US history. And for perspective, it's 2 more life sentences than the Boston mobster Whitey Bulger eventually received. He received 2 life sentences. So a pretty big sentence. So with all of my options kind of exhausted, about a year after, or no, excuse me, in February of 2012, just before the sentencing actually took place, I filed a Freedom of Information Act with the request with the Department of Justice. And on one level, the request was really simple. This is what my letter said. Basically, can I see what the jury saw during this trial? And at that point, the exhibit list, the list of, the kind of laundry list of what had been shown to the jury was a public document. I had access to that. And I attached that to my FOIA request. I couldn't have been clearer. And in case there was any confusion, I described in a paragraph all of the stuff I was asking for. And to give you an idea of what was shown to the jury during this trial, you can take a look at my second paragraph there. Lab reports, sign-in sheets, employee files, patient sign-in sheets, patient files, toxicology reports, autopsy reports, letters, DEA drug logs, PowerPoints, videos, prescriptions, all the stuff that the government showed the jury to show that this guy was a drug dealer. I was advised to file this request after a phone call with someone for the Ohio U.S. Attorney's Office with the Executive Office of U.S. Attorneys. The Department of Justice has something like 30 sub-agencies, of which the Executive Office of U.S. Attorneys is one. It's kind of the mothership for the 50 U.S. Attorney's offices based around the country. Rhode Island has a U.S. Attorney's office. Whatever state you're from has one. This guy from Ohio said, file it with EOUSA. So I did, and in late February they acknowledged it. And if you want to start the clock of how long this would eventually take, February 28th, 2012 is a pretty good place to start. That's when the government said, we got your letter, we're assigning it a number, you're in the system. Turns out it actually wasn't in the right place, because 9 months later, the Executive Office of U.S. Attorneys said, you know what, this actually isn't a good request for us. We're going to transfer this to the Drug Enforcement Administration. And we're going to charge you a $154 review fee for the 9 months of whatever work we did, which really, as far as I could tell, was nothing. 9 months, so that was November 2012. 9 months is a long time. And it's certainly a long time for a reporter who's working on a story. There's a kind of FOIA guru at Vice News. His name is Jason Leopold, who does a lot of work with the Freedom of Information Act. And he recently testified in front of Congress about what delays actually mean for reporters. And he said, "Delayed responses to FOIA requests are a significant problem for investigative journalists for several reasons. First, information may become less valuable over time. Information about a candidate is less newsworthy after the election is over. And information about a war is less newsworthy after the conflict is over. Often information delayed is information denied." Jason Leopold, just as a side note, was one of the people who sued for Hillary Clinton's emails. So 9 months passed. My story is probably depreciating in value, although that's not the main issue. It's simply that I'm not getting an answer from the government, so they transfer it to the Drug Enforcement Administration. And the DEA, for those of you who watched Breaking Bad, you know that this is Hank Schrader's agency. This is the top drug enforcement agency in the country. They're based outside of DC. They have over 5,000 special agents. Their annual budget is nearly $3 billion. They have offices around the country and around the world. And it made sense that my request would end up with them, because they were the agency, after all, that investigated Dr. Volkman. They were the ones who sent in patients of his with hidden cameras. They were the ones who scoped out the street outside of his offices when all of the people were lined up there. They were the ones who built the case slowly, so it made sense that this information battle would ultimately be a face-off with them. So they received my request in December of 2012. Around a little less than a year after my request was filed. To give you an exact idea of how long it took after that, we would have to sit here for about 2 years. I'm not going to put you guys through that. We're going to click the fast forward button and kind of breeze over what happened next, even though it was not a breeze. The DEA, over the span of 2 years and some extra months, slowly processes this request. They send me, I think, a total of 10 partial fulfillment packages. In other words, they broke up the task into 10 pieces. They said that my request pertained to over 15,000 pages of material. I didn't really know how many pages. I hadn't been at most of the trial. And not only do they take a very, 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 very long time, what they send me doesn't really line up with what was shown at the trial, because they didn't really send me much of anything. They withheld over 85% of the information I requested, and they redacted, blacked out, most of the things that they did send me. So I really didn't have much. In one case, they sent me a slideshow, I should have included it here, but I didn't, which was presented at the trial about how Dr. Volkman's prescribing practices compared to doctors around the country. And every single slide was very carefully whited out, except for the title. 133 pages. They sent me other pages that were just, just covered in black. And that was the stuff they did send me. They withheld, citing exemptions based on medical privacy, over 85%. So by the time November 2014 rolls around, we are nearing the 3-year anniversary of my FOIA request. I have very little to show for it. I've had a number of frustrating experiences, which I won't even get into. I'm making a lot of phone calls at this point. I had recently, the newspaper where I worked in Providence closed. I had a bit more time on my hands, and I was angry. And I started to really make a stink. I sent letters to my congressman. I sent letters to my 2 senators. I filed an official complaint with something called the FOIA Ombudsman at the National Archives. I later wrote a letter to Congress, and I reached out to my local ACLU, basically saying, this is crazy, this is a big trial, this is evidence that was already shown in public, they're not releasing it, they're giving me the runaround, I think this is important to you. And they said yes. And they put me in touch with 2 pro bono attorneys here in Providence, and we got together, and in March of 2015, shortly after the 3-year anniversary of my FOIA request, I filed a FOIA lawsuit against the DEA. For some perspective, in the year 2014, according to the White House, over 700,000 FOIA requests were filed. And I don't have the number for that year, but in the following fiscal year, 2015, around 500 FOIA lawsuits were filed. So less than 1% of all FOIA requests filed turn into lawsuits. And I can only speak for myself, but I imagine this is pretty representative. They get filed for a very specific reason, which is the person meant what they said when they asked the question and they got some kind of insufficient answer from the agency. In this case, we laid out the facts in our complaint and we said to the judge, please let us know whether the DEA has wrongfully withheld these documents, this trial evidence that sent a man to prison for 4 consecutive life terms. Another 18 months of legal arguments ensued. The case broke down in the legal sense to 2 pretty easy to grasp sides. We were on the side of transparency. I, a journalist, was asking for this trial to remain truly public, for the public to be able to see the evidence that sent this man to prison, to be able to get a sense of this historic trial. The government was arguing disingenuously, in my mind, that they were looking out for patient privacy. And because so much of the information presented to the jury had been sensitive medical documents that in another context would not have been releasable, that they could not release this evidence. Now, I am sensitive to medical privacy. I don't believe I have a right to see your medical files or your medical files, but I do believe that it's right there in the Constitution. Trials are public. There is admittedly a tug of war between dueling interests, transparency, medical privacy. FOIA fights are always a tug of war between dueling interests. But I felt up to that point, the government was just leaning extremely and excessively hard on that medical privacy thing. I just couldn't grasp the fact that a guy goes to prison and we see less than 10% of the evidence that sent him there. And I'm happy to report that the judge agreed with us. After a hearing here in Providence in August, where both sides presented their arguments, U.S. District Court Judge John McConnell ruled just a couple weeks ago on September 16th, about 4.5 years after the date of my initial FOIA request, that I do in fact have a right under the Freedom of Information Act to access these documents I've been asking for. He was persuaded by our arguments. In his 17-page decision, the first page of which I recently sent to the frame shop because it's going on my wall, he said, public scrutiny of legal proceedings produces a myriad of social benefits. He cited the recent true crime shows. There's the Portsmouth Daily Times, the day we filed our lawsuit. That's the town in Ohio on the Ohio River where Volkman practiced. This is an op-ed I wrote in the Columbus, Ohio Dispatch on the 5-year anniversary of the trial in which I said, my fight for transparency is not fueled by a belief that Volkman is wrongfully imprisoned, but no matter how heinous or irresponsible his actions, he deserves a genuinely public trial, one that stays public after the jury has gone home. So getting back to the decision, the judge said, because the information petition for disclosure is the very information used to convict Dr. Volkman, the public interest in this information cannot be served in any way other than by releasing the court exhibits. Indeed, these particular documents are an integral part of a serious investigation and prosecution by the DEA. The government selected each of these requested exhibits to present as full exhibits at trial. These exhibits led to Dr. Volkman's ultimate conviction and sentence to 4 consecutive life terms in prison. The exhibits Mr. Eil seeks ultimately demonstrate how and why Dr. Volkman was convicted. That is, how the DEA carried out its statutory obligations as a government agency with respect to Dr. Volkman, and how the judiciary handled the trial. He also said, in a part I particularly enjoyed, that it was very difficult to take the government's stance seriously when at so many previous junctures they had failed to protect patient privacy. They had not requested that these sensitive exhibits they filed during the trial be sealed. During the appeals process, they had published via electronic court filing system a selection of highly sensitive exhibits from the trial, which they only lightly redacted. They had made no requests to redact or seal the transcripts. The judge was basically saying, it's kind of too late for you guys. You haven't had a problem with medical privacy up to this point. I don't really buy your arguments now. So I am still, as you see me today, basking in the glow of this victory. It was I said recently in a TV interview that it should not feel like a victory when you gain access to trial evidence in this country. And I stand by that. In fact, I think in many ways I would encourage people to think of this as not a victory, but merely the end of an egregiously long government transparency failure. However, knowing how much time and energy I put into this, none of which was paid, it does feel like a victory. And lawsuits are very clean and tidy in that there is a winner. I will say that the judge who ordered the DEA to produce the documents within 60 days didn't grant absolute transparency. He did say that privacy interests could be maintained with more disclosure. He encouraged or allowed them to redact patient names, patient birthdays, social security numbers, and a few other things. It was a bit of a middle ground decision, but he ultimately said, give the guy these documents. And I should add, as I always do, because nothing surprises me anymore, November 15th is either the day that the government produces these documents and I get on with my book project, or it's the day by which they can file an appeal. If the government loses in a criminal case, they can't appeal. Only the defendant can appeal. But in a civil case, they can, and perhaps they will, I don't know. I always mention that the Freedom of Information Act fight over the release of John Lennon's FBI file lasted 14 years. So by that standard, my case at 5 years old is actually on the younger side. Or maybe they won't appeal, and maybe that will be that. So, why does all of this matter? I think it matters for a few reasons. Here's the frame, me tweeting about the framing part. It matters, of course, to me because this is the single largest project I've ever worked on by far. I'm now in year 8 of a project I started in 2009. I was an English major, not a math major. I could be wrong there. It's at least 7 years old. And I had put this book project, my first book project, on the shelf until I knew what was going to happen with this question that pertained to the very center of my story. I often referred to this trial as the center of my story, and the evidence is the center of the trial. And when people came up to me and said what was inevitably the first question they asked, was this guy guilty? I would have to say, he was convicted, but I haven't really seen the evidence. So it matters to me because I can get back to this project that I still very much believe in. And I believe in it because, A, it's a fascinating personal story. This is a guy with an MD PhD who is now in federal prison. How does that happen? That was the question that initially sparked my curiosity, and it still does. I now know Dr. Volkman personally, and I think he's an interesting character, to say the least. Not particularly sympathetic, but highly intelligent at the very least. And it's worth kind of introducing readers to him. And I believe that this country is in the midst of an ongoing epidemic with regard to prescription drugs and also heroin. The two are interconnected. And we have not even come close to getting a grip on what to do about this problem of people becoming addicted and overdosing and dying. And as a journalist, I think it's really important to tell the story, a very small part of how we got here as a country. And I believe because Dr. Volkman was one of the largest prescribers and one of the worst hit places, that this is an important piece of that jigsaw puzzle. So that's one reason why this matters. I think it also matters because of the Bill of Rights. And I, for one, kind of look at the Bill of Rights and the Sixth Amendment, First Amendment too, given my experiences at the trial, with asterisks now. Yes, you have a public trial, but I would add some fine print to that in that the evidence may not be released. And a journalist may have to fight for it for years. And if I hadn't gotten the help of the Rhode Island ACLU, I wouldn't be talking to you. I'd just be dejected, because if only for this lawsuit, because of this lawsuit, that's the only reason I have this stuff. Speaking of lawsuits, this matters because it's a Freedom of Information Act story. The US government produces an insane amount of information. This is a quote from a New York Times op-ed in 1975 that begins, "With an estimated 6 billion files, the federal government is the largest single creator and collector of information in the world." I see some heads nodding. That was 1975. We're in 2016. Who knows what that number is now? But it's a lot. And the Freedom of Information Act is a set of rules for who that information really belongs to. It's this monumental switch in 1966 that said this information really belongs to the people. And the spirit of the law says, unless you have a really good reason, you've got to give these people who pay for the government in whose name it has conducted the information. But in practice, and certainly by the time that I came to the Freedom of Information Act in 2012, that wasn't really the reality. In January of 2016, the House Oversight Committee in Congress, which is responsible for overseeing the administration of the Freedom of Information Act, released a report called FOIA is Broken. And in the introduction, they quoted a young journalist who said, "I often describe my experiences with the Freedom of Information Act as the single most disillusioning experience of my life." They didn't include a name, but that was me, from my letter to Congress. And they later included as an example of how broken FOIA is a little bit about my case. So FOIA is broken, and my case is perhaps the perfect example of that. FOIA is broken along two lines. It's broken in terms of the redactions. Agencies are routinely over-redacting, not implementing the law in a spirit of disclosure, as President Barack Obama encouraged them to do in a memo on his first day in office in 2009. And it's broken in terms of the time it takes for people to get answers. My case, again, is an example of this. I still don't have these documents in hand, and it's 4.5 years after I filed my request. And a guy who I don't necessarily believe is innocent has been in prison for 5 years, and the public still hasn't seen what he did. Now, if I, for some reason, were indicted and convicted, I would really want the public to see what I did. That's a really important thing to happen in a democratic society. This man lost his freedom, the most serious thing the government can do to a person, put them in a cage for the rest of their life. The least they can do is show us what he did. And that hasn't happened, and that's scary. And by the way, I don't think I should have had to file a Freedom of Information Act request in the first place. And I'm working with my local congressman on legislation that would mandate that trial evidence be put online. I think the Sixth Amendment in the 21st century means online. But that's another story. So don't necessarily believe me that FOIA is broken. Listen to the Senate testimony of the General Counsel for the Associated Press, who said in 2015, "We are witnessing a breakdown in the system, both on the procedural front in the form of continual delays and agency non-responsiveness, and on the substantive front with the vast overuse of exemptions and redactions." She also said, "Non-responsiveness is the norm. The reflex of most agencies is to withhold information, not to release, and there is no recourse for a requester other than pursuing costly litigation. This is a broken system that needs reform." So while it's very nice that anyone in the world, you don't even have to be a US citizen, can file a FOIA request, in fact, many people agree that in order to really get what you're asking for, you may need to sue. And it's much, much, much more difficult to file, to mount a successful FOIA litigation campaign than it is to simply send a letter off to an agency. So finally, I think this all matters because the Freedom of Information Act speaks to something very fundamental about the United States and about what it means to be a citizen in this country. I don't have to remind you that the preamble to the Constitution begins, "We, the people of the United States, in order to form a more perfect union." And on it goes. If we, the people, are going to successfully govern ourselves, then we, the people, need to know what's going on with our money and in our name. One of the things I was reminded of by this experience is every time the federal government prosecutes someone, it says the United States of America versus blank. In the case of Paul Volkman, it says the United States of America versus Paul Volkman. That means if you're a citizen in the United States, people are being prosecuted and imprisoned at this very moment, I don't mean to be a downer, in your name and with your tax dollars. So in a blog post for the Rhode Island ACLU thanking them, I wrote, "The first page of my lawsuit may say Phil Eil versus the U.S. Drug Enforcement Administration, but I urge you instead to think of it in the terms that appear on Volkman's indictment, United States of America versus Paul H. Volkman. This lawsuit is not about saying Volkman is innocent, set him free. It's merely demanding, I want to see what our government is doing in our name with our money." So, just in closing, I wanted to, thank you for listening to my story. Thank you, Nick, for having me. We're going to talk a little bit more about the Freedom of Information Act in the ensuing hour. If you had met me 5 years ago in October of 2011, I don't know if I would have heard of the Freedom of Information Act. Maybe there's a line in the movie Dodgeball with Ben Stiller where he says the hippies finally got something right. I might have heard of it from that. But I didn't know much else. And in fact, this request I filed in February 2012 was the first FOIA request I ever filed, which turned into my first ever FOIA lawsuit. Now I have written letters to Congress, as I mentioned. I've written about FOIA for Vice and Salon and the Freedom of the Press Foundation and the New England Coalition for the First Amendment and the Columbia Journalism Review. The other day on Twitter, somebody dubbed me a FOIA Jedi, which I will happily take, although I'm not sure I deserve it. And I've done a lot of research about the Freedom of Information Act and found a lot of interesting quotes. Among them is one that I'll leave you with. The first Supreme Court case about the Freedom of Information Act took place in 1973. When you pass a law, sooner or later it's going to make its way up to the Supreme Court. And 7 years or 6 years after the FOIA took effect, the highest court heard a case involving a Democratic congressman from Hawaii named Patsy Mink, who had filed a request to the White House in 1966 regarding underground nuclear tests on an Alaskan island. The White House refused the request. She ultimately filed a FOIA with the EPA. They said no. She fought it to the appeals court and then to the Supreme Court. Ultimately, she lost. And if you look at the record of the Supreme Court on FOIA, they've often ruled in favor of the government, although they didn't, notably in the case of John Lennon, which that file was ultimately released in the mid-90s. It became a documentary and a book. But in the dissent for that decision, Supreme Court Justice William O. Douglas wrote in part, "The executive branch now has carte blanche to insulate information from public scrutiny, whether or not that information bears any discernible relation to the interests sought to be protected by subsection B1 of the Freedom of Information Act. We should remember the words of James Madison." He wrote, "A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both. Knowledge will forever govern ignorance, and people who mean to be their own governors must arm themselves with the power which knowledge gives."